G'day everyone and welcome to video 4.2.7 for the Legal Studies guy. Our quote today is from Samuel Goldwyn, American film producer and one of the founders of Hollywood. And he said back in the 30s, the harder I work, the luckier I get. I think this time of year it's vitally important to remember that luck will come to you if you put the work in. And that's when you get the just rewards, obviously. Our key knowledge point today, as I said, 4.2.7, it's quite a dense one. It is the ability and means by which individuals can influence law reform. So basically, particularly focused on this, the methods people can use to influence changes in the law. Perhaps if technology's changed and you think the law needs to change to reflect that, what methods can you use to try and do that? And it gives us three things that we need to look at, particularly petitions, demonstrations, and the use of the courts. So we've obviously looked a little bit at courts and lawmaking already. Our skill will be to discuss the means by which individuals can influence law reform. That was really clear in the old study design. That meant we need to know both their advantages and disadvantages. And obviously, our essential question is just simply, how can you influence law reform if you want to as an individual person? So we're going to look at petitions, demonstrations, and the use of the courts. We're going to look at their advantages and disadvantages as well. And then we're going to look at an example for each of them. Petitions first up. So a petition is obviously a list of signatures, of a group of people who support something. So the really clear language we want to use when we're describing or defining what a petition is that it is a written specific request for change or no change to a law signed by those who support it. Now, this is really clear language that actually comes from the parliamentary guidelines into petitions, this idea that they are a written specific request. Can't just be a general request, here's all the people who are unhappy with Malcolm Turnbull. It actually needs to be a specific request to change an aspect of the law. What happens is a group or individual will organise the petition. They will submit it to the House of Representatives Petitions Committee. So there's a standing committee that runs through continuously through every parliament that is sat on by members of parliament, and they get presented all of these petitions every year. Every few weeks, I think they look at it. And then the committee then looks at it, may refer it to the relevant minister, and will present them to the House during a time slot every few weeks when Parliament's sitting. Any petition that they do refer on to the minister in charge, so say it's a petition around aspects of the GST, they might refer that on to the Treasurer or the Finance Minister. That minister will need to respond in writing within 90 days. And that response could be as simple as, thank you for your petition, we won't do anything. People may also be invited to talk to the committee in person about their petition. So they might be invited to come in and answer questions or actually talk to the reasons why they have had the petition or brought the petition. Now, for years, and it's only been a change recently, you couldn't actually use e-petitions. Petitions to the Australian Parliament had to be written petitions that were then sent in. But there's been a change in the recent years that have allowed e-petitions. And it's really interesting. If you went on the Parliament petitions website a few years ago and looked at some of their petitions, they were generally really well considered, really specific in their request, because people had to take the time to put them together and then send them in. If you go on now and look at all the petitions that are put in, they're just not very specific at all. Sometimes they're not even a request for anything. They're just something that says they're upset about something, and often only signed by 20 people who've gone on and clicked the link and signed it. So petitions have changed a bit in the last few years, but effectively they still are that written specific request for change to a law signed by those who support it. And the advantages are, as we can see, it allows an issue to be directly addressed to Parliament. So you're actually putting in your desire for change to the body who can make that change. You're not, talking to the media over here and then hoping that someone in Parliament might hear what's said on the news. You're actually going straight to Parliament and saying, this is the change that I want. They can also attract large public interest. I mean, the largest petition ever, I think, was and it might have changed recently, but that I remember was a petition into ensuring more funding or ensuring funding for community pharmacies in like rural and remote communities. 1.3 million signatures. So petitions can attract a large amount of public interest and can show clearly to Parliament that change is wanted. And they're quite easy to do now as well, which is probably an advantage as well because there are e-petitions. However, this is the really key disadvantage for the petition, is that Parliament has no obligation. Parliament could get that 1.3 million signatures on the pharmacies petition and go, sweet, we don't care. We're not going to change anything. Recently, our example we're going to look at is a petition around removing the GST from female sanitary products, which the Coalition has just come out in the last couple of weeks and said they're going to do, but didn't actually do that in response to this petition. So Parliament doesn't actually have to act no matter how many people sign it. And petitions just aren't as publicly visible as things like the media and demonstrations, which we're going to look at. You go online and you see all these petitions that you've never heard of that like 30 people have signed, and they're not going to have any impact on law reform at all. So Parliament doesn't have to act, and they're really, a lot of people won't see petitions, which are disadvantages of using that method to influence law reform. I'm not going to go through this in a lot of detail, but you can pause it and have a look closer if you like. These are from this is from the parliamentary website. These are the parliamentary standing orders on petitions. You'll see here that a petition must be addressed to the House of Representatives, refer to a matter in which the House has the power to act, state the reasons for petitioning the House, and contain a request for action by the House. And that's super important, this idea that you are requesting an action. So there is that specific request for something to be done. You'll then see that there are different rules for paper petitions and e-petitions. So you can see with an e-petition, the posted period for an e-petition is to be 4 weeks. So once you publish that petition, it will be posted up for people to sign for 4 weeks. And names can't be copied or pasted from other ones. And then there's all these rules around submitting it and what actions the House is able to take, such as the Standing Committee may refer a copy to the Minister, like I said, and the Minister has to respond within 90 days. So these are just the rules for petitions, so you can get a bit more of a deeper understanding, but effectively just a written specific request for change, given directly to Parliament. Great because they go directly to the body who can change the law, but not great because Parliament doesn't actually have to do anything. Our next method that they list for us are demonstrations. Demonstrations, aka protests, are just where a group of individuals, so group being really important. I suppose you could have a solo demonstration, but they're really important that these are group things with large numbers of people who publicly express their desire for law reform. So publicly say, we want this changed. And Australia has a really long history of demonstrations. You'll often see them in the news. Some really famous one recently have been around some protests around changing the date of Australia Day. There's been some protests around our treatment of refugees as well. There was even some rallies after Donald Trump was elected as President of America in Australia. So demonstrations are quite common in Australia, particularly in Melbourne, and they're generally disruptive in nature. This idea that they disrupt part of society, which means they get more media attention and there's a greater likelihood that politicians will take notice. So the idea that you might need to shut a street down, or it might impact public transport, the idea that people will be forced to pay attention to the message that the demonstration is sending. And this is their real advantage, this idea that the larger the better, the more likely you are to get media attention, and then, people in Brisbane, for example, might hear about this demonstration in Melbourne. And as a result, they might actually build some awareness to their cause. So it serves that educative function where people might see the protest, be disadvantaged by the protest, but actually as a result, they're like, oh, now I know about this and this is something that I want to be passionate about too. But the other side of that coin is the idea that attention can actually turn quite negative, and might actually turn people off some law reform due to the fact that they're negatively impacted by the demonstration. And as well as that, they're just hard to organise. Like, imagine trying to convince 100,000 people to rock up down the street one day. Take a lot of time, take a lot of effort, and a lot of people just don't have that available to them, and therefore it's not a good way of influencing law reform. Our final reason is the use of the courts. And look, we've covered off courts as lawmaking already in this unit. So we know courts have the ability to make law through precedent and statutory interpretation. So using the courts is the bringing of a case with the specific purpose of seeking a new interpretation of the law. So bringing a case with the right conditions where you know that the court might be able to use stat interpretation or precedent to make a change in the law. Decisions made by the court then become part of the law. They either add to the statute or they fill a gap where there is no statute through precedent. And therefore they change the way that law impacts on society, or they change the way society works because of it. Really advantageous because we know that decisions will come into force immediately. You don't have to wait for Parliament to act. The decision is handed down by the court, and then that is law. And you're not subject to the political pressures. So a lot of Parliament's inability to make law lies around the political pressures that Parliament faces. This idea of short-term voter interest, maybe not making long-term decisions because you're worried about getting re-elected. Therefore, the use of the courts is really good because you bypass all of these political pressures, these different ideologies that people have. And therefore can get the right decision straight away. Another advantage as well is the whole idea of judicial activism. There are some judges who want to be really active about updating and changing the law to meet society's needs. So that can be an advantage if you know that based on where you take the case that's an outcome that's likely. However, same two reasons that are factors that affect the court's ability to make law are simply that you need standing, and that's hard to get. And even if you do have standing, it's expensive and time-consuming. It's risky. What if you fail and have to pay the expenses of the other party? What if you fail and you've put 2.5, 3 years into something and paid all the legal fees attached to it, and you don't actually get a change in the law? And the other side of the coin is that supremacy of Parliament, that if you do get the courts to change the law, the Parliament could just override it. They could just abrogate it. And that's definitely a disadvantage of using the courts to change the law. Skill. Discuss the means by which individuals can influence law reform. So discussion, we know, means advantages and disadvantages. How good are these means that people use? And we've included the advantages and the disadvantages in those previous 3 slides. But it also asks us to use examples. So this is perhaps a sample question that you might see. Something on the lines of, using an example, explain how individuals can influence law reforms using the courts, or using demonstrations, or using petitions. So what I've done is I've just answered this question 3 times with one with courts, one with demonstrations, one with petitions, and with one example in each. So you can get an example that you might be able to use in your answers, but also just understand that skill of using an example to illustrate an answer. Our first one is influencing law reform through the courts. And our example is the Mabo case. And a lot of you would have done this at year 11 as a question of rights. And the Mabo case is a great example of a test case that was brought and overturned a previous precedent, and therefore creating a new law. In certain circumstances, individuals are able to change the law through bringing a case to the courts in a new area of law, or if a law needs interpreting. In the Mabo case, Eddie Mabo brought a case against the state of Queensland seeking to overturn the previous precedent of terra nullius, that Australia was unoccupied at the time of British colonisation. This court case changed the law in Australia by overturning terra nullius and establishing the legal concept of native title. So it's just using the case to illustrate that the law can be changed through the courts, and this happened in the Mabo case. Your next example is petitions. An example of individuals influencing law reform through petitions is regarding GST being paid on women's sanitary items, as I mentioned before. Provided they meet certain conditions, individuals are able to present a written specific request for a change in the law directly to the Parliament, signed by all those in agreement. So I've kind of defined what it is there. In 2018, over 100,000 people signed a petition asking for the GST to be removed from women's sanitary items, which was subsequently presented to the relevant minister. And as we know, the minister would have had to respond to that within 90 days. So again, using the example, people signed a petition asking for a specific request here, the GST to be removed, subsequently presented to the minister. Finally, an example of individuals influencing law reform through demonstrations is the Let Them Stay protests, hashtag Let Them Stay. In certain circumstances, individuals are able to influence politicians through publicly expressing their desire for change. In the Let Them Stay demonstrations, individuals met in all capital cities around Australia to express their desire for law reform regarding the holding of immigrants who arrive by boat in offshore detention centres. So again, using the language, so publicly expressing their desire for change, and then in my example, individuals met in capital cities around Australia to express their desire for law reform regarding the holding of immigrants. So using the example to actually illustrate what the means is or what the method is. If you go to this link, you can see all of the examples of petitions. You see the petitions list that have been presented to this Parliament. If you search EN 0494, you will see the petition into women's sanitary items. And then you've got a newspaper article on the Let Them Stay protest to have a look at as well. Another good protest movement to look up that led to a change in the law was around Oscars law, and another one around live music in Melbourne. And then you've also got the Mabo case, which many of you would have learnt before, but this website, just this PDF, gives you a brief outline of what the impact of the case was, and you can see that the courts were used there to change the law. Ultimately, what means can individuals use to change the law? How can you influence law reform? Well, that's through petitions, demonstrations, and the use of the courts. Hopefully now you know the advantages and disadvantages of each, and you know an example of each, and you can easily go out and find your own examples as well. Leaving feedback, as always, is very welcome through the comments box on our website, through comments on YouTube, through likes, through ratings, through subscriptions. Definitely share the content around as well. It'd be great to see as many people on board. This has been another video for the Legal Studies Guy. Happy studying.